Hello everyone, my name is Malcolm Smith and I am one of the academics who is convening contracts along with Leanne Wiseman. I'll introduce us in just a moment, but welcome to this first podcast. Thank you for taking the time to listen. These podcasts are intended to supplement your reading and work alongside your workshop activities. So by now you should have had a chance to familiarise yourself with the Learning at Griffith site and understand the structure of this course so that we start off the trimester with workshops and then we switch in week 6 to a format of lecture and tutorial. You should also familiarise yourself with the assessment in this course and ensure that you diarise and put into your diary those assessment dates so that you don't miss them. I would also like to acknowledge the traditional custodians of the land on which we are going to meet and where we will be teaching you, and pay my respect to the elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander people. So here is just a slide with our contact details for the course conveners. So both Leanne and I were based at the Nathan campus, but we will be convening across both campuses. Just check your course profile for your relevant course convener and ensure that you email the correct one based on the campus you're studying at. So as I mentioned, the format for this course is that we start with our workshops. Those are 2-hour workshops each week. In the first week we'll introduce the course, we'll get to know each other a bit, and then in weeks 2 to 5 we'll go through the key foundational topics for this course, so contract formation, offer and acceptance, certainty around contracts, consideration, equitable estoppel, and intention to be bound. They're our topics for our workshops. In the second half of the trimester, we'll focus on some other topics, but also some skills around problem solving and how to answer your exam questions. We'll look at formalities required in certain contracts. We'll look at the concept of privity of contract, that is about the parties to the contract and who can rely on the contract. We'll look at the terms of the contract. Now that covers a number of weeks, so we look at the terms expressly provided for in an agreement. We look at certain terms that are implied into an agreement, so they may not be expressly written into the agreement, but they're there somehow. And then we'll look at construction and interpretation of those terms. And in the final week, we'll have an overview and revise the course in its entirety and get you ready for the exam. So let's jump straight into the content of this podcast, which is focused on the notion of offer. But offer is one of a number of elements of what a valid contract is, and it's really important that you understand that for a contract to be on foot, for it to be formed validly, these elements have to be there. So you have to have an agreement between the parties. That consists of an offer and acceptance. You have to have consideration, which is some kind of promise. So a promise to pay money for a car, for example, would be the consideration from one party, and the promise to hand over that car and ownership of that car to the other for the sum of money would be the other promise. In addition, you have to have intention to create legal relations. So there has to be an intention there for you to be legally bound in your agreement. We'll examine those terms later on, but in this particular podcast, we'll focus on the notion of what is an offer. We'll consider what an offer is, and we'll look at what it is not. And sometimes it's easier to define things by excluding certain categories of what may appear to be an offer, but is not legally considered to be one. We'll look at different types of transactions and we'll categorize those and look at what is an offer. And we'll look at the requirements for communication of an offer, as well as how an offer can be terminated before it's accepted. So what is an offer? Well, it may appear to be a pretty straightforward concept. You may offer to someone else to sell things to them and they may accept that offer and then you agree to have a contract. But it isn't always as easy as that. So for example, if you walk into a shop, when is an offer made? You need to know and be able to pinpoint in the types of problems you deal with when the offer is made and by whom, so that you can determine then the acceptance that may occur by the other party afterwards. So is an advertisement an offer? What if an offer is not matched by an acceptance on the exact terms of the offer? And what is the effect if someone makes a counter offer? So if you walk into a shop, for example, on the image here, and you look at the items on the shelf, is the fact that those items are displayed in the shop effectively an offer? Or is it when you take those items to the counter, is that the offer? We'll look at these concepts and we'll explore them. But it's important to note that there is a relationship between offer and acceptance on the one hand and agreement on the other. And whilst it may be clear and easy to define that an offer is the expression to another of a willingness to be legally bound by stated terms, it is not always clear when an offer is made. So think of a really complex commercial transaction. There may be hundreds of terms within an agreement. And so if it's necessary to express to another person your willingness to contract with them based on a number of stated terms, what happens in those pre-contractual negotiations where those terms are determined between the parties? When is that offer made? Sometimes it may be easy to identify that certain counter offers or requests to change certain terms of an offer are made, but sometimes it's not. And so for this purpose, the law has come to this conclusion that it's necessary to look at what is an agreement, and if you can't pinpoint an exact offer and acceptance, then it's necessary to look at things from a holistic, global approach. So viewed as a whole and objectively from the point of view of a reasonable person, would the dealings show that a concluded bargain has been reached? So this is summarised here in the case of Hermans and Acacia Group Limited. Justice Jacobson says, "The question is whether the conduct of the parties viewed in the light of the surrounding circumstances shows a tacit understanding or agreement, as well as whether viewed as a whole and objectively from the point of view of reasonable persons on both sides, the dealings show a concluded bargain." So you can see on these slides that I've used cases as propositions around points or concepts of law. So on this slide and the previous one, you would have seen a case cited there. So in this case, we would say Hermans and Acacia Group Limited. We wouldn't say Hermans versus Acacia Group, because in civil claims we say and instead of the v. The other key point is that whenever you cite a proposition of law in your work, in either your assignment or your exam, you should support that proposition of law with a case. That's the authority that supports your statement of the law, and it's really essential that you have that. There are a number of other key factors that you will want to clarify when thinking about acceptance and offers in terms of an agreement. So for an offer, you want to think about who is the person making the offer. They're called the offeror. You also want to think about the person to whom the offer is made, and they're called the offeree. So when you are faced with a problem or a question around these issues, perhaps draw out a diagram. Think about who is saying what to each other, right? So write down party X makes a statement, and then party Y, either by conduct or in response, does X, Y, and Z. And think about which of those persons has made the offer, and you would label them as the offeror. And then to whom has that offer been made, and label them the offeree. If you can sketch out these factors as you go through a problem, particularly one for your assignment or for your exam, it may help you to ensure that you've got the right people, labeled them with the right terms, so that you reach the correct conclusion. We'll see throughout the course that offers generally don't have to be in writing. There's no legal requirement that they are, except there are some exceptions here. So, for example, when we look at the disposition of an interest in land, transferring some kind of interest in real property, we will see that there is a requirement for that to be in writing, which is set out in legislation. We also know that offers can be made to individual persons, or they can be made to corporations. So a corporation has legal personality, so they have the same rights and interests as a real person. Offers can also be made to the world at large, and in your prescribed case this week, so you'll see there are some prescribed cases for your readings each week, which can be accessed on the readings site. you would have looked at the case of Carlyle and Carbolic Smokeball Company. Now, this is an iconic contract case. You talk to anyone about contracts, and they will say, I know the case of Carlyle and Carbolic Smokeball. We'll talk about that in just a moment. But we'll also note that when making an offer to the world at large, that could potentially be a unilateral contract, and we'll look at what that means as well. Another couple of terms to get familiar with, and you're going to get used to this as you go through your law studies, as there are many specific terms that are used. And if you can pick this kind of language up as you go, it will really help you in mastering the concepts that we consider. So, bilateral contract. What do we mean by that? Well, this is the most common kind of contract. If you go into a shop and you take some goods to the counter and you are purchasing them, there's an offer and acceptance there, and we'll come to when that happens in a moment. But you as an individual are making the contract with the shopkeeper or the shop owner as to the purchase of those goods. There are just the two parties there to that agreement. That's a bilateral contract. And as I said, they're the most common type of contract. So both of those parties make a promise. They exchange promises. I will give you the right to have these goods if you provide to me the money for them. So there's an exchange of consideration, which we'll look at in later weeks. So the consideration is the promise to do something or not do something, such as pay. In contrast to that, we have unilateral contracts, which are slightly different. Now, a unilateral contract is where there is an offer made to the world at large, for example, or a specific group of persons. It's not necessarily one identifiable individual. Now, please be careful when identifying whether an agreement is unilateral or bilateral. Don't automatically assume that it's unilateral just because it's made to a group of people. Think about the facts and carefully analyze them. This is what we will be training you to do throughout your degree. Analyze scenarios, solve problems, and look closely to make distinctions. Now, the case of Carlyle is a perfect example of a unilateral contract. So the company offered by advertisement to pay £100 to any person who succeeded in catching influenza after having used a smoke ball in the prescribed manner 3 times a day for 2 weeks. It was added that £1,000 was deposited with a bank as an indication of the company's sincerity in this matter. So they were really serious about showing that they would pay this £100 to someone who became ill with the flu. Now, of course, someone sued them. That's how the case arose. But what the Carbolic Smokeball Company did was they raised defences, and they raised a specific one around the issue of intention to create legal relations. They basically argued that the advertisement was merely an advertising puff, which we'll look at in a moment. But in particular, they had said that there had been no specific offer made to an individual and that there had been no communication of acceptance to the company. Well, in this case, the court said that there was an intention to create legal relations, as the deposit of the £1,000 at the bank was evidence of the sincerity and the commitment to the agreement. It was also stated that it was possible to make an offer to the world at large. It can be capable of being accepted by a number of persons. And in this case, the offer had actually been accepted by Mrs. Carlyle when she performed the conditions stipulated in the advertisement. So in this type of contract, the offer was made by the offeror, the Carbolic Smokeball Company, and it impliedly waives the need for communication of acceptance because it is stated that the act of complying with the conditions in the advert is what would be the acceptance in this case. So one interesting thing with a unilateral contract is that the performance of the act by the offeree is what amounts to acceptance of the offer. But there isn't necessarily a requirement for them to communicate that to the offeror, and also the consideration by the offeree, the promisee, is the actual performance of the act which is set out in the offer. So we'll have a look at this in greater detail in our workshop, but have a look at the case, try and understand what is being said by the judges in that decision, and try and distinguish and make clear in your mind what is a unilateral contract compared to a bilateral contract. The other thing I'd like to say about unilateral contracts is, of course, there is an increasing amount of commerce made on the internet. There are whole ranges of websites that sell products, and they may offer certain things for sale on their website. It's important to note from the case of Smith and Thomas that offers made over the internet are governed by the traditional rules with respect to offer and acceptance, and they apply to internet transactions. So that particular case is described on page 46 of your textbook. But it was actually about an auction that was concerning an item for sale on eBay. So have a look at that case, and it does clearly establish that offer and acceptance rules apply equally to internet transactions. But also note the sections in the Electronic Transactions Act that we've asked you to look at. They are important, and you'll see there we've directed you towards section 26 capital B. Whenever you see a capital letter after a section number in legislation, as you'll learn in Foundations, that means that there's an amendment to the legislation. That particular section has been added at some later time. Okay, over the next few slides, we're going to have a look at some specific circumstances where we have to categorize whether these situations are offers or not. Now, this is really important because if you're given a problem, as in an assignment or an exam, or in real life, if you're given a disagreement where the parties are trying to work out whether or not there was an agreement on foot, you're going to have to analyze the circumstances and work out the rules that apply to those different categories. There are a few terms here that you need to be aware of. So the term a mere puff. A puff is a type of advertising slogan. So you think about certain products, they're the best you're ever going to have, they're better than their competitors. They are not considered generally to be offers. They're mere puffery for the purpose of selling a product. Now, advertisers obviously can't be deceptive or misleading because there's consequences for that. But for the purpose of a contract, those words are not relevant to an offer. If you have read Carlyle already and thought about the words in the judgment that are stated about the nature of the advertisement, think about what made the conclusion in Carlyle and Carbolic Smoke Ball different. Think about the fact that the court analysed all of the circumstances together, so it wasn't just the advert in itself. It wasn't the idea that this was going to cure your illness alone that made it an offer. There were other factors along with that, such as the serious commitment of placing the £1,000 in a bank. That also exemplifies the fact that in many of these cases, the courts have to consider all of the circumstances as a whole and weigh up the different issues to determine whether there is an offer or an acceptance or an agreement from a global view. Now, the other key thing you're going to have to be familiar with is the term invitation to treat. Now, this is a really important concept. What is an invitation to treat? Well, it's a term that's used to describe a position where the person is asking for others to make offers. So that example I gave earlier of the shop and the transaction, shop goods on display are held to be invitations to treat. So the fact that a shop displays an item in itself is not an offer. When the person picks up that item or they request to purchase that item from the shopkeeper, that's when an offer is made. And I'll talk a bit about that in a moment. In Carlyle and Carbolic Smoke Ball Company, unlike the other cases I'll mention, that was not considered to be an invitation to treat for the reasons I've just talked about. It was considered to be an offer. Another example where you're going to have to think about, is it an invitation to treat? Is it an offer? Is it some other thing? Is where there is an exchange of information. So, for example, in the case of Harvey and Facey, this is a really important case that you'll need to know. The plaintiff in this case telegraphed to the defendant, now it's an old case, so there was a telegraph, "Will you sell us Bumper Hall pen? Telegraph lowest cash price." Bumper Hall pen was a property, and they wanted to purchase this property, so they asked, are you going to be basically willing to sell it? The defendants replied to that telegraph and they said, lowest price for Bumper Hall pen is £900. Plaintiff sent a response, another telegraph, saying, we agree to buy Bumper Hall pen for £900 asked by you. Please send us your title deed. So the question here was, is there a concluded agreement? Now, in this case, the Privy Council, which was a UK court, held that the second telegram was not an offer. It was merely an indication of the minimum price the defendants would require if they actually decided to sell their property. So in fact, they held that the first telegram was a request for information, and the second response, so the lowest price willing to sell, was just a supply of that information. There was therefore no offer made and no acceptance. In the case of Gibson and Manchester City Councils, another example of where there's different exchanges between the parties. So a council tenant in that case wished to buy his council house, and they contacted the council, who wrote to them saying that it might be willing to sell the house on specific terms, but we invite you to make an application on a form. So the tenant did that, but the council actually subsequently reversed their policy of selling their houses to tenants. The council's letter contained the language of invitation to treat only, and that no contract existed. So it was held there was no agreement because, in fact, the council had asked the tenant to make the offer, and then the council had a right to refuse that once the paperwork was submitted. Now, here's just an example of some of the cases that you would have seen in the textbook. So, Pharmaceutical Society of Great Britain and Boots Cash Chemists. Now, Boots is a leading pharmacy in the UK, so anyone who's ever visited will probably have seen this on every high street. I'm from the UK, so familiar to me very much so. So the defendants were operating a self-service system in one of their shops. And this is just a normal shop service as we now know it. So customers would enter, they can select articles from the shelves, they put them in their basket, and then they go to the cash desk and pay. Now, many of these cases concern potential criminal offences. So in this case, the defendants had displayed certain drugs that could only be sold under the supervision of a registered pharmacist. So the question here was, had they put on offer drugs which they were legally not permitted to do without the oversight of a pharmacist? The court said in this case that the actual sale took place at the cash desk, so no offence was committed. And they said that the display of the drugs was merely an invitation to treat. That's an invitation for people to make offers, which they did when they took the goods to the cash desk, and then that's when the offer and acceptance process took place. Similarly, another case, Fisher and Bell, there was an allegation there that the retailer was in contravention of the Offensive Weapons Act in the UK, and that prohibited the sale of flick knives. In this case, it was stated that the shopkeeper who had displayed the flick knife was not guilty of an offence because it was merely an invitation to treat. Similarly, in this case, it was said it's the customer who enters the shop who makes an offer to purchase the item. So in those cases, we know that the display of the items constitutes merely an invitation to treat. I've already talked about the case of Carbolic Smoke Ball Company, so have a think about the reasoning again in that case as to why there was an offer and not merely an invitation to treat. But the general rule around advertisements is that they are considered to be invitation to treat. For example, in Partridge and Crittenden, this was a case where the appellant had inserted an advert in a magazine, and it stated Bramblefinch cocks and hens, 25 shillings each. So he was actually charged, again another offence here, with offering for sale a wild live bird. That was contrary to legislation in the UK. Now, on appeal, the court quashed his conviction because it was stated that the advertisement was not an offer, but an invitation to treat. You also have the case of Granger and Son and Goff, which is discussed in the textbook. We can see there that Advertisements are usually invitations to treat. That's not always the case, as we see in Carlisle and Carbolic Smokeball Company. Also consider the fact that internet advertisements are dealt with specifically under the Electronic Transactions Act. And we've asked you to have a look at those provisions for your workshop this week. So come along and be ready to discuss them in your workshop with your workshop leader. So as I go through the remaining categories here, I want you to clearly think about why it may be important to categorize each of these different transactions as either an invitation to treat or an offer. I'm not going to explain it for every one, but think about why that's important for each category. In the case of auctions, you could expect obviously that once an auction is called or advertised, how it's categorized is fundamental in terms of how then the bids made by the bidders are categorized. So if the advertisement for an auction is an offer and then a bidder makes their bid, that would bind the auctioneer or the vendor of the property. So it would bind into an agreement whereby if an offer was made by a bidder which was not really as expected by the auctioneer, they have no basis to refuse that bid. It would be a valid acceptance. For the most part, that's not how the law categorizes them, but you can see the significance of why here. For example, in cases of reserve, each bid is considered an offer rather than the advertisement or the auction itself. This means that the advertisement or the calling of an auction is an invitation to treat, and as each bid is made, that presents an offer which can be accepted. In the case of auctions that don't have a reserve, and a reserve is where, for example, the vendor will say, my lowest price I'm willing to sell is for X amount, and unless the bids reach that, the auction will not close on that sale. Where there is no reserve, the law is a bit unclear, and here it's important to recognize that the law is not always clear on every issue. Many times throughout your degree, you're going to hear the words, well, it depends. It depends on the circumstances and it depends on what earlier cases have said. Case law sets precedent, and you'll learn about this in your foundations course. A precedent will bind a judge in a future case. So for example, if our highest court in Australia, the High Court, has made a principle of law in a case, that principle will bind other judges, for example in a district court or a Supreme Court, and they are bound to follow the principles in those cases. Other principles are stated in cases, and they may be persuasive, so you'll learn about this. The doctrine of precedent, a case can form either a ratio, which is the binding principle in a case, or there can be other things said, obiter, which is persuasive. So they're perhaps things that are not directly relevant to the case before the court. The obiter comments can be influential in future cases in showing judges how to make decisions. So in these cases on the slide, in Warlow, it was said obiter that when an auctioneer calls for bids, this amounts to an offer. However, in AGC Advances Limited and McWhirter, this was instead suggested that it's an invitation to treat. Have a look at your textbook and you'll see there's a discussion there about what the better position is. Another category is in the context of tenders. So a tender is where, for example, an organisation may put out a call for suppliers to provide them with certain services or goods at a particular rate and on particular terms. And once a whole range of tenders are received, the person or the organisation that made that call can decide which is the best for them. Now you can again see here that there's significance in how these calls for tenders are categorised. The general rule is that a call for tender is an invitation to treat only, and the tender itself made by the person or the organisation wanting to supply or provide the goods is the offer. Now there are exceptions to this, and this applies where the advertisement indicates that the highest or lowest bidder will be accepted, or when the caller does not accept a tender meeting their criteria when they indicated that they would in their call. This is discussed in Hughes Aircraft case. And again, have a look at the section in the textbook on this. You'll also see that the textbook discusses standing offers. Now the case here that's discussed is Great Northern Railway Company and Witham. In this case, the plaintiffs invited tenders for the supply of goods. including iron, for a period of 12 months. The defendant submitted a tender to supply such goods over the period at a fixed price and in, and I quote, such quantities as the company's storekeeper may order from time to time. The plaintiffs accepted the tender and the defendant made several deliveries of iron, but before the end of the 12-month period refused to supply any more. The plaintiffs sued for breach of contract. Now in this case, acceptance of the tender in response to an invitation such as the one to supply iron, it results in a standing offer so that the supplier can supply goods set out in the tender when they're required by the person who accepts that. Each time the buyer orders a quantity of goods, a contract comes into existence for that quantity at the time. But there's no breach of contract if the buyer does not order any goods at all. So if the person submitting the tender wishes to revoke their standing offer, they may do so, except insofar as the buyer has already ordered goods under the tender. Contrast this with, for example, options. Now this is where, for example, there's a type of offer where consideration is provided, such as a payment, which requires that the offer is kept open for a specified period. And there's a general rule that an offer can be revoked before it is accepted. However, options cannot be revoked within the specified time. When we come to look at consideration, you'll see that in essence that's because there's been some consideration provided for the offeror to keep their offer open. The next category we'll look at is tickets for transport, and this is a really interesting one because here we need to start thinking about why we might categorize as, for example, the machine being an offer and the payment being an acceptance. It's because essentially we're thinking about terms of the contract, and we'll look at those later in the course, but essentially you'll learn that when there is an agreement, at that point the parties are bound by the terms of their offer and what's been accepted. So if there are further terms of relevance to that offer and acceptance which have not been communicated to the offeree, then generally they will not be binding. So if, for example, the presence of a machine which offers a ticket for transport has a whole load of information on it, and it's expected that the person purchasing that transport ticket will read that, and their payment in the machine is an acceptance of those terms, they can't then, for example, be bound by different terms that may be displayed on the train carriage or on the bus. They're bound by the terms that were identified to them at the time the contract was made. And this becomes really important when you start looking at, for example, exclusion of liability for some kind of personal injury or damage to property that may occur, and whether that was communicated at the time the offer and acceptance was taking place. So the key thing is that the presence of a ticket machine will amount to an offer, with the payment being acceptance, and any exclusion or liability limiting clauses on the back of the ticket will not be binding because the ticket is provided after the payment. However, if clauses were introduced before the payment, then they will be binding, such as on the machine. If the ticket is not, however, issued by a ticket machine, then there are perhaps different principles that you need to think about. In relation to public transport tickets purchased on the spot, in these cases it's the passenger who is the offeror, and the acceptance is made when the transport provider takes the money and provides the ticket. So any terms that appear on the ticket are not binding as the contract's already been formed. When there's a reasonable time to view the terms, such as those purchased through an agent or online, the passenger is the offeror. The issuing of a ticket is a counter-offer. The passenger accepts by paying and not objecting after a reasonable time. In relation to internet transactions, it's helpful if you look at your textbook at 3.245. Also consider McRobertson Miller Airline Services and Commissioner of State Taxation, WA. The next category involves vending machines or ticket machines, commonly found in, for example, car parks. So you drive up to a car park, you see the boom gate, you take a ticket and you go in. Where have the terms been expressed in relation to the offer, and when is the offer made? So the case of Thornton and Shoe Lane parking is an interesting one, And this really focuses again on those issues I was just talking about, where the terms of the contract are really important. For example, where one of the parties has tried to exclude liability and the other party wishes to argue whether or not those terms are incorporated. And the timing of the offer and acceptance are central to this, because any terms that are made after the agreement has taken place are not binding on the parties. So determining at which point, for example in a car park, the taking of the ticket and entering, at which point in that transaction an offer and acceptance occurs is fundamental. Because if, for example, the driver of the car takes the ticket, enters the car park and sees that they're bound by a whole set of additional terms that were not made clear to them prior to entering, the question becomes, are they bound by those terms? This exact issue occurred in Thornton, and the driver Mr. Thornton entered the car park, took the ticket, came back to his car and was injured as a result of negligence of an employee in the car park. The car park owner tried to argue that they were not liable for negligence or any injury to the user of the car park because there was a notice inside the car park which said all cars are parked at the owner's risk. Furthermore, on the ticket itself, it said that it was issued subject to conditions displayed in the premises. Now, in this case, Lord Denning was particularly concerned about the fact that notice was given by means of the wording on the ticket, and by wording that was contained only inside the car park. So he conducted a detailed examination of the exact time of the making of the contract with the machine, and concluded that by the time Mr. Thornton took the ticket and had a chance to read it, the contract had already been made. So the existence of the clause was communicated too late, and it was therefore invalid. So this was important. The making of the offer occurred when the owner of the machine holds it out as being ready to accept the person into the car park and receive the money for payment. Once the offer is accepted by taking the ticket, it's too late then to add any further terms on it. We might return to this case later in the trimester, because it was also said around the exclusion clause that it's necessary that a type of clause like this, which limits liability, has to be prominently displayed to the person before they enter, before the contract is agreed, so that they are bound by it. So there you can see a range of different cases where different transactions are categorized in different ways. It's really important that you're aware of these different categories and that you can apply them to a problem that you're given. Make sure you go through the textbook and summarize the key circumstances of when these transactions are either invitations to treat or when they are offers. It's also important to be aware of the fact that an offer has to be communicated. So it must be communicated to the offeree. That's the person who will potentially accept the offer. And it must be communicated by the offeror or their agent. Now, there's good reason for this, as explained in the textbook, and it may be that the offeror intends to make an offer to the offeree. However, until that time that the offer is communicated, it's open to the offeror to change their mind. So, if an unauthorized person were to communicate the intention to make an offer, and the offeree accepts, it gives the offeror no chance to think about whether they actually genuinely want to make the offer to the person concerned. The other thing is that an offeree cannot generally accept an offer of which they are unaware. The communication must come from the offeror or agent, as detailed on the slide. But note the position around offers made to the world, those unilateral offers. The other issues to consider are around a termination of an offer, and it's important to remember that, of course, a person who makes an offer can at any time withdraw that offer before it is accepted. So that offer is not binding on them should they change their mind, and as long as they have communicated the withdrawal or revocation of that offer to the offeree. In relation to revocation of offers, just bear in mind that there are a few issues around this that you have to think of. So again, making sure you've identified the type of offer you're dealing with. Where there is an option, and remember I spoke about that in the context where, for example, the offeror will keep the offer open for a certain period of time, then as long as there's consideration accompanying that to make that a valid option, the offeror cannot withdraw that option. Contrast that with the situation where there is no option, or no option accompanied by consideration, and the offeror can withdraw the offer at any time before acceptance. It's important to remember that, of course, once an offer has been accepted, it cannot be revoked. That's fundamental because at that point, when the offer is accepted, there is an agreement in place. Revocation is only effective once it's been communicated and received by the offeree. And again, a very important point. Note that the postal acceptance rule, and that doesn't make any sense to you at the moment, but when we consider acceptance next week, we'll look at this rule. This does not apply to revocation of offers. The postal acceptance rule only applies to acceptances. Communication of the withdrawal can be effective if made by a reliable third party. And again, this is another example of where an authorized person can make representations between the parties which can bind them. But if it's not a reliable third party, then it will not be effective. That was exemplified in the case of Dickinson and Dodds. Now, this is an older case where it involved the sale of a house. So on the 10th of June, the defendant offered in writing to sell his house to the plaintiff for £800. And this was to be left over until Friday 12th of June, 9 a.m. On Thursday the 11th of June, the defendant sold his house to a third party. And that evening the plaintiff was informed of the sale by an agent who had handled the transaction. Before 9 a.m. on the 12th of June, the plaintiff handed a formal letter of acceptance to the defendant. In this case, the Court of Appeal in the UK had to deal with the fact that there had been an offer kept open until the Friday, but the vendor had sold before that to a third party, but that was communicated by the vendor's agent to the offeree of the original offer. So the Court of Appeal held in this case that the communication was actually made by the agent to the original offeree, and that communication of the fact that the offeree could no longer purchase the property because it had been sold to someone else, effectively a revocation of the original offer, was made before the acceptance took place, which meant that it was a valid revocation because it was communicated by a reliable third party, the agent who was selling the property. So in the context of unilateral contracts, we know that quite often the act of acceptance will be some form of conduct itself. For example, in Carlisle and Carbolic Smokeball Company, it's important to note the full court of the Federal Court's position in Mobil Oil Australia Limited and Lindell Nominees Proprietary Limited. One further issue to consider with the revocation of an offer in a unilateral contract is that where an offer is made to the world at large, it's probably necessary to revoke the offer in the same way that it was initially communicated. So that's also discussed in Carbolic Smokeball Company. So perhaps the placing of an advert in the same way as the original offer. Note that once an offer has been rejected by the offeree, then it no longer stays open. It's no longer up for acceptance. It's also important to note that an offer will be terminated if the offeree comes back with a counter offer. So when a counter offer is made, it terminates the original offer, and the person cannot then come back and say, okay, I'll pay the full asking price and you're bound to sell it to me now, because their original offer has been terminated. Do note, however, that not every term added will be sufficient to amount to a counter offer. In other words, not everything that the offeree says will terminate the original offer. It's also important to distinguish the fact that if someone asks for information, the offeree is not coming back with a counter offer there. They're effectively just clarifying the terms of the offer made by the offeror, and that does not extinguish the original offer. Third, to be effective, rejection of the offer must be communicated to the offeror. So if the person is rejecting the offer so that it is no longer open, that must have been communicated to the offeror in some way. Just some last principles here to think about: the fact that an offer can come to an end if the offeree does not accept within a prescribed time. So like some of the cases I've mentioned in this podcast where it's been stated that the acceptance must be received by a certain date. If the offeree does not accept within that time, then the offer is no longer on foot. And if there is no time prescribed, then it must be instead within a reasonable time. So in the case of Ramsgate Victoria Hotel, the defendant had applied for shares in the plaintiff company in early June 1864. The shares were allotted to him in late November 1864. So some months later, and the defendant refused to pay. It was held in this case that the defendant was not liable since the company's response had not been made within a reasonable time. What is a reasonable time will always depend on the individual circumstances of the case. Have a look through your textbook and what is discussed there. And as I mentioned there, failure of a condition can also amount to lapsing of the offer. So if there are conditions stipulated, I've already mentioned one, such as must be accepted within a particular time frame, non-fulfillment of those conditions means that the offer will lapse. Finally, consider the position in the textbook around the death of the offeror. So this is where the offeree knows of the offeror's death. Have a look through your textbook there because there is a distinction made. So in the case of Dickinson and Dodds, so as stated in Dickinson and Dodds, it is admitted law that if a man who makes an offer dies, the offer cannot be accepted after he is dead, for it makes the performance of the offer impossible. Of course, if it's a type of offer relating to the performance of personal services, then it's impossible to perform that once the person dies, and so it's implied that the offer will lapse. In contrast, a contract for the sale of property may still be able to be carried through once the person has died, because the acceptance can be communicated and that could be dealt with by the representatives of the estate of the deceased. And lastly, think about the other circumstance where it's the offeree who dies, and in this case it's most likely that the offer lapses. So in conclusion, summing up the purpose of this podcast, it's been to introduce you to this idea of an agreement. What is necessary for an agreement to take foot? An offer has to be made. You have to understand the difference between when there is an offer and when there is mere puffery, such as advertising, or when there is an invitation to treat, so an offer to make offers. So we know that an invitation to treat does not form a legally binding offer that can be accepted. It is really important to be aware of the different categories of offers and other categories such as invitations to treat that have been outlined in this podcast, because that will determine when an offer has been made and by whom. So if, for example, you know that the display of goods in a shop is an invitation to treat, you can work out the fact that it is the person who goes into the shop seeking to purchase who makes the offer in that contract, because they take the goods to the counter, and whether they are sold is then determined by the owner or the shopkeeper who may accept that offer for the sale of the goods. Of course, we also talked about the fact that it may not always be possible to pinpoint the exact time that an offer or an acceptance is made, and in some transactions it will be necessary to have a global analysis of the agreement. In the next topic we examine the concepts of acceptance, and we'll learn that once an acceptance takes place, there is a binding agreement there, and so long as it is accompanied by those other key factors that I talked about, such as consideration and an intention to create legal relations, there will be a binding contract which can be enforced in some way. Thank you for listening. If you have any questions about the content of this podcast, please do ask those of your workshop leader and come along to your workshop ready to discuss those questions that you have been asked to prepare. Thank you.